Thank you. We are now joined by Grant Varner. He is Fox Carolina's legal analyst as we continue to follow the case of Alex Murdaugh. Thank you so much for being here.
Anytime.
Okay, so there were a couple of motions that were filed in this case today. One was a Brady motion. What exactly is that?
So in any criminal defense case or any criminal case whatsoever, you're going to see what's called a Brady motion and a Rule 5 motion. They're both motions for discovery, and what you're asking for is the state to provide any evidence it has in the case, any evidence it intends to use to go forward, any exculpatory evidence which may assist in the defense case. So a Brady and Rule 5 motion are nothing more than, hey, we want everything the state intends to present at trial, and we want it now.
Okay, so so that's just mostly something that would normally happen in every case?
Standard procedure. Every criminal case I've ever been a part of, that's the first motion I file. And it's back to back, Rule 5 and Brady motions, and they go out in the mail with the letter of representation.
Yeah, so the Rule 5 was what I was also going to ask you about. Also, the defense has asked that there is a gag order in this case, but the judge made sure to point out that this is a public procedure that will take place in the public.
It's my understanding at this point it is going to be a public trial. I mean, all trials are public, but there are no, warning signs right now that this may be a sealed hearing or that the courtroom doors may be closed to the general public or the news media. But I've also been told that the defense and the prosecution have agreed to keep all evidence secret at this point. In other words, they're not going to disclose anything. So it's sort of a self-imposed gag order. I suspect they're doing that to try and prevent tainting a jury pool statewide. I mean, it's already going to be difficult to find a jury pool. I assume they're doing this to try to help protect that.
So much exposure to this case through podcasts, newspaper, TV coverage. How difficult will it be to find a jury?
It's going to be tough, and it's going to be tough for both sides. Where I anticipate the trial is going to take place in the lower part of the state, Alex Murdaugh and the entire Murdaugh family has been loved and well respected in that area for decades. And then you have these heinous accusations, some of which he's not denying. I mean, he hasn't denied any of the fraud. Mm-hmm. And so you're going to have an equal number of potential jurors now terribly upset with him. I mean, this is a person in a position of trust. Attorneys are fiduciaries, in our relationship with our clients. We are, supposed to be trustworthy, not doing what he did. And so you're going to have a lot of people very upset with that, but you've got a number of people down there that still love him and believe in him. Yes. So it's going to be tough for both sides.
So at this point, he has pleaded not guilty to the deaths of his wife and son. Is there any way that he could modify that plea and, bring in possibly insanity? Is that a possibility?
He could declare, 5F, we call it a 5F, motion for insanity defense, basically saying I'd lost my mind at that point in time. I was on drugs, I was out of my mind, I didn't know the difference between right and wrong, I was totally insane, and this was in a fit of rage and just out of my mind, so I shouldn't be held culpable. I don't know that that'll work in this case because obviously at that time he was still out there working.
And the defense attorney is asking for a speedy trial. They want to get this done ASAP. Why?
From a defense perspective, in a case of this magnitude with so many moving parts, the faster the defense moves, the less prepared the prosecution may be. Now, the defense has asked trial within 60 days of receiving all available discovery. So that's not necessarily 60 days from, tomorrow if they get the evidence, because they only get part of it, but 60 days from the day they have all the discovery. There's no hard and fast rule in South Carolina that says that's the number. It has to be 60. And the rules actually, there just can't be any unreasonable or unnecessary delay. With the number of witnesses and all the forensics that are going to be involved, you would be hard-pressed to convince a judge that anything is unreasonable or unnecessary simply because of all the moving pieces in this. So I don't know that we'll see a trial this year. We might, but I don't know that we will for sure.
Okay, so our next thing we're going to wait for are the written order. It really is the written order from the judge in this case, whether he'll decide on a gag order for future hearings and procedures. But we hope to catch up with you later on and learn a little bit more from your expertise. Thank you so much, Grant Varner, our legal analyst for Fox Carolina News. Tori?